निवडणूक आयोगाचा निर्णय झालाय. मात्र आता नमस्कार दर्शको, मराठी महाराष्ट्रामध्ये आपल्या सगळ्यांचं स्वागत आहे. मी संग्राम. निवडणूक आयोगानं निर्णय दिला. अजित पवारांची राष्ट्रवादी आहे, म्हणजे घड्याळ अजित पवारांकडे गेलेला आहे. निवडणूक आयोगाचा निर्णय झालाय. मात्र आता विधानसभेमध्ये निर्णय राहिलेला आहे, तो म्हणजे आमदार अपात्रतेचा. आता निवडणूक आयोगाने निर्णय दिल्यानंतर विधानसभा अध्यक्ष राहुल नार्वेकर यांच्या दालनामध्ये हा निकाल आहे. ते जाऊया तर राहुल नार्वेकर जे आहेत ते निकाल देत आहेत.
Were grouped as Group 1 and petition number 2 and 5 filed by the Ajit Pawar faction were grouped as Group 2. I would be pronouncing two separate judgments in these two groups. In the facts and circumstances of the matter and in view of the facts that the rival factions had emerged within the NCP prior to the initiation of disqualification petitions, I had to determine which faction was the real political party for the purpose of these disqualification petitions as per the law laid down by the Honorable Supreme Court in Subhash Desai matter. This issue is common in both the groups. So what I shall proceed to do is, I shall first pronounce the order in Group 1, where I shall first deal with the preliminary issue and then deal with the issue with regards to disqualification. And then we'll follow with the second petition, group. So, the Honorable Supreme Court in Subhash Desai versus Governor of Maharashtra, hereinafter referred to as Subhash Desai, was pleased to hold that the Speaker should prima facie determine who the real political party is for the purpose of adjudicating disqualification petitions if two or more factions claim to be that political party in keeping with the principles discussed in the said judgment. A bare perusal of the pleadings in the present matter indicate the emergence of two factions within the NCP, the Ajit Pawar faction and the Sharad Pawar faction. Although the said judgment was in the matter that arose from a somewhat similar political situation that arose in the House concerning the Shiv Sena, it does constitute a precedent that would apply on all four of the petition present disqualification matters as well. Hence, keeping in view the similar factual matrix and the law laid down by the Honorable Supreme Court in Subhash Desai Supra, I will prima facie determine which faction is the real political party for the purpose of adjudicating these disqualification petitions. The said preliminary determination is necessary before examining the merits and deciding whether respondents have incurred disqualification under the 10th schedule of the Constitution of India. Therefore, to quote, the preliminary issue that arises for my consideration before delving into the merits of disqualification petition under the 10th schedule is which among the two factions was the real NCP political party for the purpose of deciding the present disqualification petitions. The other issue framed for my consideration in this group of disqualification petitions is whether the respondents have incurred disqualification in terms of paragraph 2(1)(a) of the 10th schedule of the Constitution of India on account of their alleged acts, omissions and or conduct. So we'll go to the analysis, observations and the findings with regards to which amongst the two factions is the real NCP political party for the purpose of deciding the present disqualification petition. In view of the fact that in the present matter rival factions have emerged and both the factions claim to be the real political party, read with the law laid down by the Honorable Supreme Court in Subhash Desai Supra, stipulating that this forum should prima facie determine who the political party is for the purposes of adjudicating disqualification petitions if two or more factions claim to be that political party. It is necessary to consider and determine the preliminary issue before examining the merits of these disqualification petitions. Principles laid down by the Honorable Supreme Court in Subhash Desai relevant for the purpose of determining who the political party is. I am not reading out all the contents of the Subhash Desai which we have referred to and relied upon. I will straightaway go to my observations. Thus, what emerges from the principles laid down by the Honorable Apex Court is that the question of who the real political party is has to be considered and determined after giving due weightage to 1. The constitution of the political party, 2. The leadership structure of the party, and 3. The legislative majority if two or more factions claim to be the real political party. The question as to who the real political party is hereinafter referred to as the preliminary issue. Since in these proceedings both the factions are claiming to be the real political party at the relevant point of time, and as the said issue arose for determination in these proceedings on 16 January 2024, the said preliminary issue was also framed as one of the issues in these disqualification petitions, thereby affording an opportunity to the parties to make their submissions on this point. I proceed to consider and adjudicate on this. I would be adjudicating the said preliminary issue based on 1. The principles laid down by the Honorable Apex Court, 2. Record available with the Maharashtra Legislature Secretariat, and 3. Submissions made and documents referred to by the parties during the course of the hearing in these disqualification petitions. Petitioner's submissions on the preliminary issue, I am not going to go into reading those submissions again. They are a part of my order which you can refer to. There are also observations with regards to the respondent submissions on the preliminary issue, which also are there in my order, which I wouldn't be reading out at this point of time. Analysis, observations and conclusions on the preliminary issue. As recorded earlier, the decision of the preliminary issue has to be taken after careful analysis of 1. The constitution of the NCP, 2. The leadership structure of NCP, and 3. The legislative majority. After having heard both the sides on the above aspects, I now propose to proceed to record my observations and findings on the preliminary issue. In the present matter, there is no dispute as to the relevant NCP constitution. Both the parties have placed reliance on the constitution and rules annexed as Annexure R1 and R2 to the reply filed by the respondents. The said constitution of the NCP and rules are hereinafter referred to as the NCP constitution and NCP rules. On 30th June 2023, a resolution was passed by 41 legislators of the NCP electing Shri Ajit Pawar as the president of NCP. A dispute under paragraph 15 of the symbol order was also preferred by the Ajit Pawar faction before the Election Commission of India. Sharad Pawar faction objected to the resolution dated 30th June 2023 and executed affidavits in support of the leadership of Shri Sharad Pawar, which were filed before the Election Commission of India. Thus, it is abundantly clear that two rival factions had emerged in the NCP on 30th June 2023 itself. Hence, the relevant date on which two factions emerged in NCP is 30th June 2023. As recorded earlier, there is no dispute about the relevant constitution of the party. Thus, the said NCP constitution is taken into account for identifying the leadership structure of the NCP. Since there is no factual consensus on what or who constitutes the relevant leadership structure which has to be taken into consideration, it is necessary to peruse the NCP constitution so as to identify the leadership structure provided for in the constitution and consequently examine the leadership structure put forth by both the sides. Article 5 of the NCP constitution read with NCP rules provides for a vertical organizational structure which consists of unit committee, city division committee, area committee, town committee, panchayat committee, constituency committee, district committee, regional committee, union territory committee, state committee, working committee and national committee. Each committee at the bottom level acts as the feeder cadre for electing the next immediate higher committee. Article 12 of the NCP constitution provides that the state committee shall consist of delegates elected from the constituency block committee. Further, NCP constitution provides that all members of the state committee shall be delegates entitled to vote in the election of the president. National committee of the NCP consists of 1/10 of delegates. The president ex-president of the party who have completed a term of 365 days and continued to be an active member. State presidents of the NCP, leader of the NCP legislative parties, and other 15 members elected amongst the members of parliament. Article 21 of the NCP Constitution, read with NCP rules, provides that the highest executive authority of the NCP is NCP Working Committee, which consists of the President of the party, Leader of the party in Parliament, and 23 other members, of whom 12 members are elected by the National Committee and the rest are appointed by the President. The said Article 21 further provides that the highest executive authority of the party, i.e. the NCP National Working Committee, shall have the power to carry out the policies and programs laid down by the party, and it shall be the final authority in all matters regarding interpretation and application of the provisions of the NCP Constitution. The NCP Constitution, read with the NCP rules, provides that the President shall preside over National Convention, National Committee and Working Committee, and shall have overall control of the working of the party. It further provides that any decision connected with policy matters or on other important political issues will be announced by the President, and nobody shall openly question or challenge any such decision or statement. Thus, what emerges from the above is that the leadership structure of the NCP consists of 1. The President of the NCP, 2. the Working Committee, and 3. the National Committee, where the President and the Working Committee are the decision-making entities of the NCP. Thus, the leadership structure of the NCP, with reference to the President and the Working Committee, are the relevant entities for the determination of the preliminary issue. Accordingly, according to the petitioner, again, leadership structure relied on by the petitioner is a matter of record, which I am not reading out again. According to the petitioner, a valid leadership structure in consonance with the NCP Constitution exists, as is evident from the letter dated 15 September 2022 issued by Shri T.P. Pitambaram Master, addressed to the Election Commission, intimating details of organizational elections held in the year 2022, and 2. the internal NCP correspondence by way of notification dated 15 September 2022 issued by Shri Praful Patel, intimating the national office bearers, working committee members, state union territory presidents, etc. Petitioner primarily relies on these two documents to establish the existence of a valid leadership structure, and further submits that the Sharad Pawar faction had the majority within the said leadership structure, based on the reasonings which are a matter of record. The respondent, however, countered this leadership structure on the grounds that the said leadership structure cannot be taken into account, as the said leadership structure came into existence without following the due process of election appointment as provided in the NCP Constitution. In this regard, the respondent made the following submissions, which is again matter of record. Even though the preliminary submissions of the respondent on the leadership structure is that no leadership structure exists which can be a basis for rendering any finding on the preliminary issue, the respondents in the alternative relied on the resolution dated 30th June 2023, whereby Shri Ajit Pawar was elected as the President of the NCP. Relying on the resolution, the respondent submitted that the constituent members of the leadership structure were changed by electing Shri Ajit Pawar as the President of the party, and if any leadership structure must be considered, then it must be in which Shri Ajit Pawar is the President. The petitioner disputed the aforesaid claim by submitting that the alleged event of 30th June 2022, as claimed by the respondent, are inherently improbable, and the election of Shri Ajit Pawar was not in accordance with the procedure prescribed by the NCP constitutions. Findings and conclusion. At the very outset, I wish to make certain observations. Even though both the parties have submitted, probably owing to the tenor of the observations of the Honorable Supreme Court, that preliminary issue has to be decided on a prima facie assessment of material on record. In fact, both the parties have, contrary to their own submissions, led extensive evidence to buttress their respective arguments with facts in respect of the relevant leadership structure. Be that as it may, I am not inclined to diverge from the Honorable Supreme Court's directives to consider evidence of both parties in respect of validity and or illegality of organizational stroke leadership structure, in which it was this position of prima facie assessment that I adopted in my final order dated 10 January 2023, when I proceeded to decide the disqualification petition number 1 to 16 of 2022, the Shiv Sena disqualification matter, where I have already held that jurisdiction under the 10th schedule only mandates a prima facie adjudication as to what leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not leadership structure was pursuant to a validly held election. It is a matter of fact that till 29 June 2023, there has been no contemporaneous challenge to the leadership of Shri Sharad Pawar as the party president. However, the said position was sought to be altered by the Ajit Pawar faction by way of the resolution dated 30th June 2023. Thus, prima facie, as on 30th June 2023, there existed two parallel claims in respect of the NCP leadership, the one according to the petitioner claiming Shri Sharad Pawar is the party president, and the other one claimed by the respondents where Shri Ajit Pawar is the party president. In order to try and demonstrate that their separate claims to the leadership of the party by their respective presidents, both the parties have led oral and documentary evidence and argued exhaustively. Both the parties claim that it is their leader who was validly elected according to the NCP constitution, and the claim of the other side therefore cannot be entertained. Furthermore, both parties claim that other side's claim as to the leader's election as the party president was not accordance with the NCP constitution. As noted earlier, under the 10th schedule, while deciding the preliminary issue, I cannot go into the validity and or legality of elections to the leadership. I am therefore confronted with the rival assertions which clearly indicate the existence of two persons claiming leadership of the party. It is to be noted at this juncture that the respondent number 1 to 9 of petition number 1 of 2023 joined the government on 2nd July 2023. The resolution electing Shri Ajit Pawar came to be passed on 30th June 2023. This leads to a peculiar situation where there are seen to exist two parallel leadership structures and two party presidents prior to the alleged conduct attracting disqualification. Undoubtedly, the rival parties have tried to lead evidence to justify their opposing stand about the validity of the election of their leader to the post of president. They have tried to show how their separate processes of election were justified by the NCP constitution. I am not inclined to go into their evidence or appreciate their evidence-based arguments, because this would lead deciding whether the rival elections were in keeping with the constitution and the rules, and whether factually Shri Sharad Pawar or Shri Ajit Pawar were validly elected, or whether in fact Shri Sharad Pawar had resigned at the relevant time. I possess no jurisdiction to issue any such declaratory orders. In the absence of such jurisdiction, which is certainly not available under the 10th schedule of the Constitution, or the wherewithal to examine the correctness, validity and legality of parallel claims of valid stroke legal elections, I need not and cannot undertake such an inquiry. Thus, for this reason alone, relying on the test of organizational stroke leadership structure to examine the two parallel rival claims in respect of the leadership about the post of party president, I cannot arrive at even a prima facie decision on the preliminary issue. Irrespective of my findings herein above, if the leadership structure relied on by the petitioner is looked at even for ascertaining the prima facie position, it is seen that it cannot form the basis for determining the preliminary issue for the following reasons. The petitioner's reliance on majority in NCP working committee cannot be taken into account for determining the preliminary issue, as the composition of the NCP working committee relied by the petitioner is not in conformity with the NCP constitution. Article 21 of the NCP constitution, read with NCP rules, provides that the highest executive authority of the NCP is NCP working committee, which consists of 1. The president of the party, 2. Leader of the party in parliament, and 3. 23 other members, of whom 12 members are elected by the national committee and rest are appointed by the president. A perusal of the documents relied on by the petitioner to show the composition of the NCP working committee indicates that the NCP working committee had 28 members, whereas the NCP constitution provides for only maximum 25 members. The said document shows 16 permanent invitees, whereas the NCP constitution does not provide for any permanent invitees. The petitioner submitted that in the national committee, Sharad Pawar faction enjoyed the majority support amongst the delegates elected from the state committees. However, the petitioner has not provided any document which reflects the election of such delegates. Thus, in the absence of any record reflecting the election result and names of delegates, the said claim cannot be accepted by blindly appreciating it to be true. Thus, the submission of the petitioner that Sharad Pawar faction enjoyed majority support in the national committee cannot be relied upon to determine organizational majority. Support of the president and or will of the president is not a reliable factor to determine the preliminary issue, as both the factions challenges their respective leaders, claiming that the leader was not validly elected. As held earlier, under the 10th schedule, such claims cannot be adjudicated. It was open for both the parties to have initiated appropriate proceedings to get a declaration to that effect. In the absence of such proceedings or any findings thereon by a competent authority, both the factions cannot equally claim that the rival faction's leader was validly and or not validly elected. Thus, for reasons recorded here and above, I hold that leadership structure relied on by the petitioner and or respondents cannot be taken into account for determining the preliminary issue, as it would be an impossible attempt. Legislative maturity considered. As recorded earlier, the Honorable Supreme Court in Subhash Desai Supra has held that the question of who the real political party is has to be considered and determined after giving due weightage to 1. the NCP constitution, 2. the leadership structure of the party, and 3. legislative majority if two or factions claiming to be the real political party. Having arrived at the conclusion that leadership structure and or organizational structure does not provide a reasonable outcome to settle the issue of which faction is the real political party, I now turn to the test or mechanism that exists based on the legislative majority. Before delving further, the petitioner's submission that legislative majority cannot at all be taken into consideration has to be considered. The petitioner has placed reliance on paragraph 102 to 111 of Subhash Desai Supra in support of this submission. However, a careful reading of Subhash Desai Supra shows that the said submission is misplaced. Paragraph 102 to 111 of Subhash Desai Supra deals with the issue of who appoints the leader and the whip of the party in house. In the said regard, it was held by the Honorable Supreme Court that it is not the legislature party but the political party which appoints the whip and the leader in the house. The ratio cannot be read to mean that the legislative majority cannot at all be considered while determining the preliminary issue. In paragraph 168 of the Subhash Desai Supra, the Honorable Supreme Court has in clear terms laid down that for the purpose of disqualification petition, the Speaker, while deciding the issue of real political party, has to take into consideration the leadership structure specified and identifiable from the constitution of the party along with the legislative assembly majority. The only rider provided is in the said paragraph 168 was that determination of who the real political party is must not be based on a blind appreciation of legislative majority. This is only a rider provided so as to make it clear that even the leadership structure outside the legislative assembly is also a relevant factor in the determination of who the real political party is. It also indicates the legislative majority. It also indicates that legislative majority is also a factor that is not prohibited from consideration. Thus, the submissions of the petitioner that legislative majority cannot be taken as a factor in arriving at a decision on the preliminary issue is not correct and hence rejected. Needless to mention that it is well settled by Supreme Court that where the question arises as to which group is the party, strength of each group becomes an important and relevant factor. It is thus obvious why the legislative majority becomes relevant creation to be taken into account to decide which faction is the real political party. In the present matter, the legislative majority is undisputed. The respondents claim that Ajit Pawar faction had the support of 41 out of 53 MLAs is not disputed by the petitioners. Even otherwise, the resolution dated 30th June 2022 passed by the Ajit Pawar faction shows that prior to joining the government, Ajit Pawar faction outnumbered the Sharad Pawar faction. It is also imperative to note that the very fact that the Sharad Pawar faction has filed disqualification petitions against 41 MLAs of the Ajit Pawar faction itself indicates the numerical strength of each faction. Further, the respondents' assertion that they have majority in the Legislative Assembly of Maharashtra, Legislative Council of Maharashtra and Legislative Assembly of Nagaland has not been disputed by the petitioners. It is made clear at this juncture that affidavits annexed by the respondents to the affidavit in lieu of examination in chief of Sri Anil Bhaidas Patil RW2 was not taken on record and thus not relied upon for my finding that prima facie Ajit Pawar faction had the legislative support. The respondents' assertion that even the vote share secured by the legislators supporting the Ajit Pawar faction is sustainably large than the legislators supporting the Sharad Pawar faction is also not disputed by the petitioners. It is to be also noted that the petitioner has not claimed legislative majority in the manner and has not even attempted to demonstrate it. Thus, in view of the above, I hold that preliminary issue as to which faction is the real political party is discernible from the legislative majority which existed when the rival factions emerged. Further, I hold that the Ajit Pawar faction had an overwhelming legislative majority when the rival factions emerged. Final conclusions on the preliminary issue. Thus, in view of my findings that the party constitution and leadership structure, organizational structure does not provide any reliable outcome to the question which faction is the real NCP political party, and consequently these cannot be yardsticks to determine which faction is the real political party, and to the legislative majority provides a clear and reliable answer to the question of which faction is the real NCP political party, I hold that the Ajit Pawar faction is the real NCP political party for the purposes of these disqualification petitions. Issue number 2. Have the respondents incurred disqualification in terms of paragraph 21A of the 10th schedule for the Constitution on account of their acts, omissions and or conduct? Now, with regards to this second issue, it's common again to the extent of the contents to group 1 and group 2. However, considering the importance of this issue, I may read it out in the second order as well, second group as well, even at the cost of repetition. The petitioner has concluded The petitioner has contended that the respondents are liable to be disqualified on the following grounds. The respondents have gone against the official position of the NCP political party and joined hands with Eknath Shinde BJP government in Maharashtra on 2nd July 2023. The respondents have taken oath as ministers in the Eknath Shinde BJP government in Maharashtra on 2nd July 2023. Unilaterally and without authority, the respondents declared Shri Ajit Pawar as the president of the NCP on 30th June 2023. Unilaterally and without authority, the respondents declared Shri Ajit Pawar as the leader of the legislature party in the Maharashtra State Legislative Assembly on 30th June 2023. The respondents attempted to continue a chief whip who had been removed as a member of the NCP for indulging in anti-party activities. The respondents attempted to create confusion by opening party office without authority. Without any authority, the respondents called an open national convention on 5th July 2023 to ratify the illegal decisions on 30th June 2023.